Hello, and welcome to the second part of the presentation, Poli-Sci for Health Professionals. In part one, we discussed federalism, or the separation of powers between the federal and state governments. Now we'll look at separation of powers between different branches of government. At both the state and federal level, governmental authority is divided into three branches of government: the executive, the legislative, and the judicial. Each branch has separate roles, and each is also a source of different types of law. Here is this image of how the branches of the federal government are broken down. The legislative branch is called Congress at the federal level, and it has two chambers, the House of Representatives and the Senate. A bill must pass both chambers in order for it to become law, and laws enacted by the legislature are called statutes. The executive branch is shown here as well. It's important to note that administrative agencies, such as the Department of Health and Human Services and the Environmental Protection Agency, are part of the executive branch. And finally, here's the judiciary. We'll talk first a little bit about the legislative branch, which enacts statutes. Legislatures can change existing statutes by amending, repealing, or replacing them. In a health policy class, we would cover in greater detail the various committees and subcommittees in Congress and the state legislature that impact healthcare. For this class, however, just understand that statutory law is created by the legislative branch, and that statutes can be enacted to modify the existing common law created by courts. In enacting statutes, especially where there are highly technical issues involved, legislatures will delegate rule-making authority to an administrative agency, which we'll talk about a bit more. The next branch is the executive branch. Led by the president at the federal level and the governor at the state level, the executive has the power to sign or veto pieces of legislation, issue executive orders consistent with existing statutory law, and supervise the execution of laws and other governmental activities. Also within the executive are administrative agencies. And as you will come to appreciate throughout this class, many of the legal obligations impacting healthcare are administrative regulations or rules issued by a variety of state and federal agencies. Here is an example of the interaction between the legislative and executive branches, where the legislature creates and delegates administrative rulemaking authority to an agency. Specifically, the Idaho legislature enacted the Medical Practice Act, which defines what the practice of medicine is, makes it illegal to practice medicine without a license, and creates the Board of Medicine to oversee the licensure of physicians in the state. In the Medical Practice Act, the legislature grants the Board of Medicine authority to issue administrative regulations or rules that govern its operations. These regulations then have the force of law over physicians practicing in the state. Once an administrative agency has created its administrative rules, it has the authority to adjudicate cases based on its own rules and regulations. So here's an example. The Board of Nursing has authority to decide or adjudicate how to discipline a nurse for misconduct. And that could be a reprimand, license suspension, license revocation, and so forth, based on its own rules or regulations that it has promulgated. And the process of adjudication creates a type of administrative common law. And then the agency may look back to prior cases to see how they were decided in adjudicating a present case. Finally, we get to the judiciary or the court system. The role of the judiciary is to resolve disputes by applying constitutional law, statutory law, and the common law. In applying constitutional law, the judiciary may review whether another branch of government has exceeded its delegated authority. Courts will also review actions taken by administrative agencies. And there are different levels within the court system, with lower courts initially handling trials and then higher appellate courts. Here is an overview of the federal judiciary, and state judicial systems generally have a similar structure. If there is an applicable statute or constitutional provisions, courts will apply that provision in deciding a case. Where there is not, courts will apply what is called the common law, American common law is derived from English common law, and it is a body of legal precedents that were established in similar prior cases. Because the common law was developed by courts, courts have the power to change and adapt the common law to accommodate the changing context or values and policies of society. However, this is a slow process. One example of the common law changing over time is the revocation of the doctrine of charitable immunity. Historically, hospitals were facilities that served primarily poor people and relied almost wholly on charitable contributions from religious or similar organizations. In this context, courts developed the doctrine of charitable immunity, which meant that a charitable organization, such as a hospital, was immune from civil legal liability. In other words, you couldn't sue a hospital. But as times changed, wealthier people would use hospitals and pay for their services. Hospitals would bill insurance companies for payment, and hospitals could purchase liability insurance to protect themselves in the event of a lawsuit. Accordingly, courts changed the common law to reflect this change in context by doing away with, in most states, or significantly limiting in a few states, the doctrine of charitable immunity. Regarding the evolution of common law, this is a famous quote by Oliver Wendell Holmes, who would go on to be a U.S. Supreme Court justice. It is revolting to have no better reason for a rule of law than so it was laid down in the time of Henry IV. But bear in mind that if a court were to change the common law in a way that was very unpopular, the elected officials in the legislature could enact a statute readopting the old rule. And then this statute would supersede the new common law pronounced by the courts. Courts also interpret the meaning of statutes as applied to specific circumstances or cases. Where the language of a statute is ambiguous, courts must apply the statutory language as written, even if this is contrary to the apparent intent of the legislature in enacting the statute. If the statute's language is ambiguous, however, the court will then look at the context in which the statute was enacted. This may be the floor debates and similar materials to try to interpret what the legislature was trying to accomplish when it enacted this law. Courts also review actions taken by administrative agencies. For example, let's say that a nurse gets his license revoked by the Board of Nursing, and this nurse feels that it was wrongfully revoked. He could challenge the action by the Board of Nursing by bringing a lawsuit. But in order to challenge an action taken by an administrative agency, a person must first exhaust any administrative remedies before the case will be ripe for a judicial decision. Generally, after an administrative agency makes an initial determination, an agency has some sort of appeal process. Anyone protesting an administrative decision must go through or exhaust all of these internal administrative appeals processes before he or she can file a lawsuit in court. So going back to the example of the nurse who had his license revoked. Let's say that it was revoked because the nurse failed to attend enough units of continuing education classes. But let's say he really did attend some classes, but because of a record-keeping error, the Board of Nursing never received the record of his attendance. And then the letter the Board of Nursing sent to the nurse telling him that he still needed to attend continuing education classes got lost in the mail. So the nurse did not know that the board didn't have the records. There is no sense in bringing a lawsuit over something like this. That could be worked out through an internal appeal process. Finally, courts also interpret the Constitution to determine whether statutes are unconstitutional or not. An example of this would be the litigation over the constitutionality of the individual mandate provisions in the Affordable Care Act that we discussed in the earlier presentation and that we will also discuss in greater detail later in the class. In summary, the purpose of the judiciary is to resolve disputes, and the courts only get to chime in on an issue if there is a dispute or case that is brought before it that relates to that issue. But bear in mind, in resolving disputes, the courts can create precedent. And so while courts have a limited role in government in that they only resolve disputes that come before it, decisions by the court have a very big impact in that courts often have the final say on a matter. Thank you for your attention. I hope this has been helpful for you in understanding the American system of government.